Law Institute, University, Bhopal. He has a consistently brilliant academic regard that boasts first-class first honors with distinction from Ravenshaw University, UGC National Scholarship, Merit Scholarship from JNU, National Award for Essay Writing from Center for Civil Society, New Delhi, and UNFPA, etc. He holds a doctorate titled Culture, Development and Entrepreneurship, a study of silk traders of Chanderi, focusing on the entrepreneurial dimensions of traditional crafts in Madhya Pradesh. His junior research fellowship produced an important work on the sociological aspect of ecology, general and sustainable development in particular. During the last few years, he has worked extensively in the areas of globalization, tribal development, and culture of consumption, besides sociology of law. With over 27 years of academic excellence, Professor Mohanty has led major research projects from the World Bank, the Ministry of Law, and National Commission for Women on diverse issues like management, Bhopal gas tragedy, World Bank, MOEFA, engendering criminal law and implementation of PCPNDT Act, Rajiv Gandhi Advocates Training Scheme, Ministry of Law, Government of India. A recipient of the prestigious fellowship from the European Union, he has published more than 70 research articles in leading international and national journals, including Economic and Political Weekly. Beyond his research, he is the member of a state supervisory board of implementation of PCPNDT Act in Madhya Pradesh and has conducted extensive training programs for judges, lawyers, and corporate executives from organizations like Vodafone India. Today, he joins us to share his vast expertise on socio-legal research, collecting data, and analysis techniques. So, we welcome you to address our participants.
Thank you, Namrata. Thank you very much for that introduction. So I'm happy to let you know that Namrata was once my student. So I am really happy to find her in the other side of the fence. Now she's a colleague. So thank you. And now she has given me a topic to discuss with you on socio-legal research and in relation to the technological development in the field of law. Now, of course, that's a very pointed area. More often than not, we are all looking into an understanding of research methodology in all disciplines, be it science, natural sciences, be it social sciences, humanities, and law. And then why we actually require methodology and what is its relevance? Though many students, those who are studying law and other disciplines, are often say, "Sir, we are here to study law, so we have no understanding of legal research and methodology, particularly. At best, we are only know about cases and case laws. So we'll compile them, we'll write a moot court memorial, and that is it. And we do not need much of research methodology." But if you look at the whole idea of research methodology and its importance, you will find that no knowledge, substantive work can be produced without research. Many times, I often ask my students to look into a definition or meaning of their subject, and all we will find essentially that all subjects talk about our knowledge and production of knowledge. And then we find the way to approach knowledge are often divided. So we distinguish knowledges from science, to social science, to philosophy, humanities, etc. Those who are student of law, they would often know that in jurisprudence, when you talk about theories of jurisprudence, understanding of philosophy of law, so we often quote great German jurist Hans Kelsen. And Kelsen once said that law is science, pure science of law, pure theory of law. And when you talk about pure theory, they of course mean a scientific validation of law. For many years, the lawyers were on either side, whether law should be treated as science, or law is a part of social science, or law is just a knowledge of just argument. But as things developed, so we find that today law becomes a field or interdisciplinary area of increasing interaction between all fields of science, humanities, social science, right? So what you find that a student who is studying law want to practice intellectual property rights, want to practice medical law, health law, want to study cyber law, or even criminal law. He has to understand a bit of science. Even you practice medical negligence or even a common tort, negligence of tort. So you would know the human body, you would know the physiology. If you want to study IPR, you know science, industry, technology. If you know communication science, if you want to practice biotechnology law, even sports and sports medicine. So you would have a fundamental understanding of science. Similarly, if you want to argue a case, even beyond forensics, you would have developed a methodology to collect information. You have to argue, and your argument must be based on evidence. So how do you collect this evidence is of critical significance. So it is this sense that we talk about entire field of knowledge is a production of entire field of law is a production of knowledge, and in that you need to be aware a lot of techniques, and some of the techniques that you do research, even if you don't do want a PhD or doctorate, even if you do an LLM dissertation, we all want to how we'll approach the study. Many times when you teach sociology or economics, or political science, or even law, we say that it is science, law as a science, sociology as a science, or scientific discipline or scientific study. Then what is essential to that? The essential element when you say about science is that it's a systematic study. So how you can make systematic study and how you can produce new knowledge, new facts, it depends upon what methodology you follow. So methodology in that sense, as you learn from other subjects, or in this FDP course, just a method is a device, it's a procedure, right? And in the procedure, we used some techniques. Now, someone would ask me, sir, what is that method? Then we always did the scientific method, how scientists approach their field of study. If it's in astrophysics, it's chemistry, it's biology, how do they approach their field of study? How do they generate knowledge? How do they develop theory? How do they get facts? In pure hard science, they need a laboratory to work upon. In our case, we need, in social sciences, they need the existence of society. In psychology, they look at the individuals and their mindset, their attitudes and attitudes. In economics, they look at policies, development policies, economic growth, entrepreneurship, etc. In law, we look at facts, we look at cases, we look at evidences, we look at principles, and then we look at established edicts, and then go about that. Even if you want to pose a question, even if you want to answer a question, in both ways, you must have an understanding of intricacies of that. So if I want to say that my client is innocent, then how do I say by mere saying is not enough? Because even if you want to say, that must be either based on a logic or based on a facts, based on analysis or based on interpretation. In law, we have a course called interpretation of statutes. So if you look at interpretation, how do you interpret a particular statute? If there is a word is F or if word is the, so how do you interpret them? Whether they give a different meaning, same meaning, or similar meaning. That we need to look into those definitions, look into those dimensions for that. Similarly, if I say that this particular thing, this particular model is available elsewhere, so I must produce it. I must have a facts before me. So collecting facts, arranging those facts systematically is a method. And that is why we need to learn methodology for that. Similarly, also people will see things, same things maybe differently because they approach things differently. We look at the world, for instance, at the social sciences. We say the same world, the market. Everybody is in the market now. We buy our things from online market. We purchase from online market. We go to market in our marketplace complexes. Right, everybody is in the market one. Somebody works in share market, somebody buys in share market. So we are all into a process of market or merchandising, either as a participant, as a buyer, as a seller, or an onlooker. But even then, we look at many things happen. A marketer who publishes things well, who advertises well, often gets better selling. He need to know how to approach his market, how to bring things which are in demand, and he creates a demand or it meets a demand. So both way you find there need to be method. But that is why when I'm talking about market, look at, if you are a Marxist, then you see the market is a very, very exploitative mechanism. You said poor have no role to the market. When I go to big markets, say in multi malls, say about in Delhi, Gurgaon, Mumbai, elsewhere, malls are now everywhere. And you go to the up markets, big showrooms, Allen Solly, Big Boss, Carrot Line, so about like tennis. So you wouldn't go. Then a poor man feels where is he located at? He said, no, I can see it outside beautiful, but I don't have the courage, I don't have the money to buy. So for he is, and he feels that he's exploited. And Marx looks at that. He said, these creations of demand are nothing but exploitation of poor by the rich. If you're a middle class man, you think, okay, I have a Maruti, I want to go and buy to some, if not a Mercedes, or sometimes I buy it to a Toyota, right? So you are thinking market as opportunity where you can even given the limited money, you have a choice to buy things, products. If you are a rich man, you said, okay, I will change my cars every 2 years or every year, and I want it as used, or I want to show it off. So everybody, it depends. How do you look at malls? How do you look at markets? These are all like our interpretations. These are all in the sense what I call as methods of looking at things. So if you look at things from perspective of poor and rich, we call it a Marxian perspective and a Marxian approach or a Marxist method of class analysis. If you are, and in the sense, you look at, I'm looking at interpretation of things. That same things can be interpreted differently in different time, in different context. If you are listening to people, generating their information, you are a methodologist. If you are into, say, travel village, talking to travel people, looking at the problems, looking at the implementation of Forest Rights Act, then their access to land. So you are entering into what we call a participatory research appraisal. So there are different, that is why there are approaches and methodologies. And now coming to this law. So primarily when you look at law, we only look at the textual interpretation of law. What is there in the text and how do we interpret those texts? But law is not merely a dead letter law. Law is a growing, evolving field. And therefore, as the time changes, as society changes, then law has to change. And you all know there is a saying which may look very big in a sense, but a very fundamental saying, which says there can be an existence of law, but there can be existence of law without there cannot be any existence of law without society, though there could be existence of society without law. So for law to exist, there must be society. And if society, if society is a pre-requirement for existence of law, then social factors, social processes, social dynamics would have an impact on law itself. How do that affect law? And how we present our cases, either in court or in tribunal or in general theory, that we need to know that. And for that, we require a significant amount of research. And that is why in knowledge, and then, a production of knowledge is also possible through research. As you see, our understanding about cybernetics, our understanding about atomic theory, our understanding about chemical reaction, our understanding about metallurgy, our understanding about artificial intelligence, it all depends upon different forms of research. So researchers has given us, whether it is medicine, whether it is engineering, whether it is thermodynamics, whether it is any other field, you say, all the knowledge that you are getting is a product of research. So therefore, research and science are essentially entangled or interlinked. And that is why entering into field requires the involvement of research. And I would like to share with you that this is where our course and research methodology stands. Now I wanted to share with you my slides so that I would be in a position to let you know how I approach this course on this particular session, right? So look at certain things I want to share with you, slides that I want to share with you. This, you see, it's what research actually makes. Think about you, that as a student of law in a BA course or up in a graduation course, in a LLB course, so you have found yourself is like, no, I do not know what law is. I often say my class, though in joke, I said it is very difficult to teach law or to do with law because there are only two laws. One is outlaw, whom nobody wants to associate criminals. Other one is in-laws, right? But the thing about law itself, and then as science, we study about laws, natural law. Then what type of laws we talk about? Laws of thermodynamics, as I said, laws of motion. So we also talk about those laws. Now, generally, if you study Boyle's law, Charles' law, we look at laws in science because there are definitive procedures. Similarly, when you try to understand them, you find you have no understanding of them. They look far off in a classroom than really practice in the courtroom. And you say, if you practice in the court, why do you go to the classroom to learn certain things which I do not understand is head and tail? Right. So therefore, you find yourself as a caterpillar. You said, okay, you don't know your capacity. You think, okay, I am just lowly insect. Everybody has. But as you grow, as you shade your inhibitions, as you increase your procedure of enlightenment, As you devote yourself in studies, so a transformation, what is called metamorphosis, takes place. So from larva to pupa to still butterfly, and then beautiful butterfly that flies. So that is what law transforms. That is what the transformations when you understand the nitty-gritties of law, the nitty-gritties of legal studies, the nitty-gritties of legal process. And that is what I think in this courses, methodologies, methods will transform you in different. Then I would say, what is the understanding when you say about a student, say, why do I study law? And what is the need of methodology, I would say. And I said at the beginning, there are different methods. Look at the three definitions of what definitions of law I have shared with you. I am sure you must all of us have known. Even if you do not know, doesn't make difference. What's the difference? Because I want to explain that for you why methodology is critical to this understanding. Someone says the law is a living thing. So that is what I said. Law is not something fixed in it, called fixed in a sense and pigeonhole. Law is there, which emerges, which changes, which is dynamic process. That is why I said, for all 180 odd years, when we in India had Indian Penal Code, we are looked by colonial law. And suddenly we have new criminal laws. And we have changed, we want to Indianize law. Although there is a lot of almost 80-90% similarities, but still there is not much. That's a living thing, therefore new laws are required. If you look at the current law, you find that how you look at the imposition of fines, how you are looking at the use of technology in law, either in terms of establishing forensic laboratories, either in terms of looking at digital evidence, either in the process of presenting the culprit through video conferencing, right? So presenting argument through video conferencing. So you look at that as different, it's a living thing. So things are changing law. So we didn't have a Information Technology Act because society changes. So you have to respond to the changes. We're looking at now a different a law looking at transforming or meeting the demands of artificial intelligence. We have a right to artificial productive right laws. So you look at these things were not there, but as society demands, you have to change. And that is why the legal dimensions are very important to look at law as a living thing. And of course, Holmes also says law is about experience. Now experiencing for things, and therefore our experiences teaches us about law. And the art of law is the art of persuasion. John Adams, third president of United States of America, say it's an art of persuading. How do you persuade? It's not that you look handsome that can persuade people. It's people do that, charismatic personality. But there are of course areas you can persuade people based on your logic, based on the language you use, the exactness of the language you use, the fairness you take. So it's the art of persuasion. And obviously, that's a very interesting law. A good lawyer knows the law. A great lawyer knows judges. Now, of course, it's about interrelationship. It's an anonymous quotation, but it also says that you know judges means you are also able to understand the social context of it. You understand where the judge is looked at, whether he is aware of the changing dimensions, and whether he was. There are many lawyers said this judge is actually a relief-oriented judge, so let's wait for him. These are of course issues that is practicability law, and that is also you look to research. You know what type of many years ago you used to say that Justice Kuldeep Singh is as a green judge because he was supposed to give judgments largely in favor of environmental issues. And therefore, you know that if it's an environmental case, the judge has interest in it, he will listen to it, and he will give direction which is in accordance with law. So thereby, you have done a research on it. You have you looked at it, how he works. So for that reason, you need to know that. Similarly, of course, there are different dimensions of English words saying that law and other things. But again, lawyers, what's the do will change. So law is an embodiment of the moral sentiment of people. Blackstone's are saying. So it's moral sentiment of the people. That means a society. So you would know what type of society and what type of laws are required, and how, if there is a problem, the changing of aspects of law that we need to look at. Many times in India, we find people say, okay, if there's a problem, we create a law that will solve. When Nirvaya case happened, we had a knee-jerk reaction, and we immediately amend the criminal law, and so criminal law amendment Act 2013 was introduced, saying that, look, this is how we define law. How do we deal with law? But actually, if law would have solved problems, in India, we would not have any problem at all, because India is, in fact, an over-legislated country. So the idea is that, but if a moral sentiment, that is what it's a moral sentiment, that people wanted that we need a stricter law to penalize. Our conscience were aghast, and we wanted that bigger punishment. Similar punishments happen when we look at cases of acid attack victims. Cases after cases happen. We looked at disfigured, hapless women standing in front of us with scars, mental and physical scars. So we needed to protect them. So law will protect them. Then how do we do that? So that protection would come, the sentiment was there, that we must do two things. We must fix heavy punishment for the criminals, and we must protect the interest of the victims, particularly restituting them in society. So that's a moral sentiment. Similar sentiments are there now in different ways. Now you see, only yesterday the government of India decides that we will scrap the NEET examination, change it, and then immediately there is a lot of what happened to the students, what happened to their preparations, what happened to their values, what happened to their hard labor, what happened to their psychology. So these are all issues, and suddenly people would think we must make a NTA or any examination stand proof so that students should not undergo such trauma. These are all in essentially, as you talk about the social dimensions of that. And that is what I want to share, as the linkages. And where do researchers come? And that is why I look at defining law. Is it a conflict resolution, or whether it's an enterprise of human conduct, subjecting human conduct to the governance of rules, or it's like laws. So we look at law in all the dimensions. Are there social dimension into it? Many times when I have given the task of the socio-legal research field, and I think law is primarily social. If you look at these definitions, and then all there are jurists, right? Roscoe Palmer, the Dean of Harvard Law School, and says that it's a mechanism of conflict resolution among conflicting parties with competing interest. So when we look at law, we look at law in terms of conflict in society. It's a conflict resolution mechanism. So there are conflict between students and teachers, there are conflict between corporations and corporations, there are conflict between one individual and another individual, there are conflict between government, the state and the individual. So there are an employer and an employee. So a whole lot of things you find. There are different groups and different interests, and a law has to arbitrate between them. Law has to provide justice to that. So in that sense, it becomes important to know that law is essentially become social then. And similarly, if you look at the other aspects, you will find as an enterprise of subjecting human conduct, and law exists for human beings. So if there are people, there will be law. Now, if we are dealing with people, then we must have an understanding of the nature of people. And that is what the social dimension is about, that we need to know law, that is the approaches of the study of law, or this human examinations of legal issues. So look, there is a human element in that. And we cannot practice law unless until we know the nature of human beings. How do they operate? How do they ask? What questions happen? For instance, when I say why it is a human conduct and why it is logic and experience. Now we have a law which says that the principle of doli in capex. Said a child below 12 years who is not in a position to commit any crime because he would not know this, its meaning of it. So in that sense, that's a human experience that we know that human beings do operate in such a manner. And that is why understanding of human nature, understanding of nature of social grouping groups, and understanding group dynamics is important, in understanding law. And that is why we look at the lawyers, look at conscience. So in terms of Roscoe Pound, it says law's efficiency, the social conscience of it, and the court delays. So all these things are litigants' problem. And we think that how a litigant would work. I used to teach, the sociology of law, and I give an example of Mark Allen's work, where he said there are different approaches. People approach law differently. There is a group of people whose experience of law is often bad. So they just approach the court for one and two solutions. And if they are got it in their side, that's also okay. If it is against them, that's also the stop. This is experience is bad one, especially those who are suffered from a law like a custodial battle, a divorce settlement. They would think, okay, we had gone to the court and actually, or even in property disputes, they would say, okay, we have gone to the court and it is so much delay and then all issues, then probably you are better off without going to the court. And that's why the mediations are now coming. Similarly, there are other group of people who find a benefit in law. They said if it is lingered, if it's strengthened, the other party would lose interest and I will win. And then they said, okay, if I have somebody's land and I have occupied it, I'll go to the court and court said, okay, stay out of this. If it is my custody, so I'm enjoying it till 40 years or so. So if there are a lot of people who enjoy that, and they use law as to support them. And therefore, Marx once said the law is actually supporting the capitalist because it protects their interest. Well, agree and disagree with that perspective, but that is certain some truth in that also. So that is why when you look at the law and understanding of law, we look at these dimensions, and that is why it is. And if you look at the law's nature, you find it is social norms, and they all regulating human behavior. And we look at the orderly law, and that law has to be coercive. Otherwise, there's no definition difference between law and morality, because morality something is just followed, but in law we have to coercion in that, and then we institutionalize that pattern. Look at the corporate law or criminal law, how we're institutionalizing things, and then it is maintain that effectiveness so that our people will fear of law. They said, okay, we must follow the law, we must obey the law. That is what is essentially the nature. Now, how do you study those things? Right, I would say in other chapters that how do we study all those things like that is why research method is important, because we use research method in a sense to collect, analyze, and interpret data. One such research questions of hypothesis. So when you say about certain issue in a research method, you look legal research and take an example. We look at a lot of problems. In Indore, a few problem here in ocean. A lot of people died because the water was contaminated. I look at this, our problem was water contamination and consequent death of people, or a serious threat to people's health. So that's my problem. Then my question is, why this happens? This is a question, why this happens? So I want to hypothesize. It happens because there is a negligence on the part of municipality, in the municipal corporations, right? I say negligence. So I want to test the hypothesis. Whether really the Indore municipality, which is supposed to get one of the Swachh Bharat award, best award, has it really been negligent in terms of protecting the interest of people as far as their health is concerned? So you want to test that hypothesis. So to test that, I have to know really it is what are the steps that IMC should have taken but has not taken. Regular inspection, number of staffs, right? Desanitizations, detoxification, whether all these things are done or not. If they are not done, then on that basis, data I will collect, I will say that, okay, it is a negligent act on the part of Indore Municipal Corporation. So like techniques, but how do you collect that evidence then? We can use new other things, understand, create a better understanding by many times that, okay, we can be, see, like as far as the waste disposal is concerned, we might see, look at how the new techniques that are using waste to convert waste into energy, and waste also become a source of revenue. So when you look at that, you also do a research on that, the waste management practices and the principles, and how empirically it can verify those things. So in terms of simple research, it's an investigative process to search, to explore, and validate hypotheses. And that is why hypothesis is important. Now, in all social legal research, as I say, that we look at the social dimension of the law and implementation of the things, whether in terms of a particular law is valid, what is its impact. Like Dowry Prohibition Act, somebody said, no, 1961, amended in 1983, we find the law is there. But the law is there, but it is rarely practiced in it. So it has been failed law. So its impact is the less, I can say. On the contrary, if I say that, look at human rights, how human rights law has been helpful in people. Yes, many cases, though human rights violation that takes place, but the existence has certainly reduced human rights abuses to a large extent. So how can I say that whether a particular law has in its implementation has reduced it or increased it, or it has not done any change in the ground level? So to arrive at that conclusion, I need research. And for that, I have hypothesis. For that, I have to have collect data. For that, I have to analyze the data. For that, I have to interpret data and then to achieve a purpose. So methods in that sense, and then give a perspective. Look, law there. Some cases, some areas, it is very useful thing. Some cases, it is not. Right. And therefore, somewhere it needed stricter implementation, some in order to be more effective. Somewhere it is latter relaxation sometimes, and somewhere there is a deficiency in law itself, which it need to be taken in. Like if you look at when we are concerning with medical termination of pregnancy act, now so many problems happen. The law fixed that 20 weeks, then should know we have to extend it to 26, 28 weeks. Then if that a child is in position to bear to the child, in a rape cases, then government said, okay, we have to support them. There's a board of exam will be there. Now these clauses were not there. But as and when we find number of cases on that, so do we find there could be a loophole in the law. And that loophole comes through the serious study of cases. And who does those study of cases? Who collected evidences and facts and present before an argument? This requires a method, that requires technique, and then it requires a perspective for that. So we do develop the strategies to study things, to examine them. Right? There are many perspectives. I wanted to share with you the different perspectives in social legal research. And I say in a positivism. Somebody said, no, theory of legal positivism. And we discussed about positivism means that there is a means to end a relationship. We experience several things. So we use those methods. We don't believe in simple theories, but they believe in what is an experienceable reality, and they examine not what is given in the text, but what is actually happening in the context. So like we think what there are many laws which are reform oriented. Say our child marriage prohibition act. Now we see whether it is really is happening. Some actors have happened, like we see Bandha Mukti Morcha around cases, and so the abolition of that Contract Labor Act. Now we think that essentially has actually reduced, right, abolitions of Bonded Labor Act. And if you look at that, that act really been very, very helpful. So in ground level, there are people, of course, there are different level of contract labor now coming into our bundled labors are almost finished, but there are cases you find in the rural, remote areas, travel areas, that still there are cases. But nonetheless, if you look at positive wise, you find that there is a element, that the problem in society, there is a law, and law has been helpful in eradicate that. So that is. Secondly, we look at other paradigm as conflict, that existence of law, how it has helped one vis-a-vis others. Somebody would say even Aadhaar Act. Say, look at, it is there to facilitate things. Then people say, we are unable to access them. And every other asks me a mobile number. I do not have a mobile number. If you have a mobile number, it is not working. So how do I get it? Whether the data is important for this and whether my data is safe or not. And people say, okay, it is a government sponsored one. So government has all our data. But remember, I'll give an example. In 2014 elections, when Modi government won for the first time, the BJP government won like national election. And then that's it. Before that, the government of the Reliance Jio become free access to free mobile services, right? You use Jio prepaid services for free data with the data and with calling. And for that, to get a Jio SIM, you have to do a finger imprint. And they said this Jio company actually taken our finger imprint and our biometrics, and they all put into EVM unknowingly, not known to us, and therefore all votes are gone. Whatever I voted, it is voted to the BJP because Keshav supported that. You will find such arguments, and even correctly or incorrectly. Now, many times we think there is a conflict paradigm. Some people think that people use the resources, especially legal resources, towards their advantage. And many companies, many institutions, many governments use their advantageous position of law to thrust upon their point of view against others who have lack of access to them. In fact, our entire work on human rights, access to law, maybe law presents to protect us, but whether we are in a position to access to law and use it towards our benefit, forget about advantage. So we will find a large number of cases. The poor, the marginalized, the diseased, the women, the children, the destitutes have suffered a lot of harm because they do not have a legal remedy. And even if they have a legal remedy available to them theoretically, they are not in a position to do that. So therefore, presence of law in that way is a conflict paradigm. But this paradigm is important. We may not agree with them, but it's also important if there is slightest problem in that. So you must use that method, find out loopholes and fault lines in the law. Then there are methods like interpretive understanding and what is called hermeneutics. We need to interpret certain laws and their presence with that and say what it actually meant. Further, those interpretations can actually help. There is sociological perspective on understanding law. Law has a symbolic value, and then of course Marxism also finds critical in social theory. These are sociological theories which actually helps us to give a new method, like when it's discourse analysis. Many times I find it's a reflection in mediation and negotiation. So when we do negotiations, we look at being in the other position. And as a negotiator, I would know that where I can go, where I can push, and whether I can actually mediate based upon my negotiable ability. Because I want to negotiate things. So something you give, something you take. So that's possible only when you know the human nature, whether that person is really interested to arrive at a solution. Many times we find the brothers are entangled in the legal discourse, legal case for a long period of time. So even though in the process both have been ruined, they said only our ego. I don't want to lose. I want to lose my money. Whatever I have would probably work. But I don't want to lose face. In such cases, we need certain psychological therapy to understand that it is in the end, it is not really true. In the end, it is the solution. Many times things happen that way. So I think when the Lok Adalat, other things are coming, they are also a mechanism to mediate things because they try to, methodologically using discourse analysis, what is called a victim computational things, to give a new insight into the practice of law. Okay, happen you may not see now. Now, similarly, when you go to the field, what benefits we get from social sciences? Because law as a methods are few. Law didn't use methods anything except interpretation of other things as methods. But the interdisciplinary nature of it. Now the national new policy and education talks about increasing emphasis on increasing emphasis on interdisciplinarity. So interdisciplinary stage, we learn from other fields. So lawyers are trained to learn from other fields and they look at observation. So many cases, a lawyer need to observe things, courts, court proceedings, cases, behavior of the clients. So these are again observation can do that. We can observe really the impact of a particular law, its implementation issues, on its comparison between existing law and previous situation. So we can observe certain in the field that a particular law has actually bring benefit to people or not. We would look at this law, which is called the Manrega Act, now called VVG Ram Act. Like we look at whether actually it has bring a realistic change in providing employability to people at grassroots level. Right, we look at those things. Similarly, if we don't have that, we look survey. We ask people how many people have been benefited by it, whether their economic standards have gone up, whether the standard of living has gone up. So that you can possible to solve. A lot of legal searches are now surveying things, that is client satisfaction. Look at it. In proceeding support, another one also. We look survey as like domestic violence. We need a survey method. How many people are suffered? Many people say that okay, it is within the houses, and it is also very important in custodial matters. Now, when you survey research, we do the things that we look at custodial matters. Who can actually help? The law says the best interest of the child. Law stops up there, but we have found evidence to where the best interest of life. Ordinarily, any of us say mother will have the best interest of life. If mother is drug addict, if mother is suffering from emotional distress, if the mother is unemployed, if the mother is dancing on elopement, so will she take best interest of the child than the father who just compared to that? Now that needs the evidence. So that we look at. Similarly, we can arrive them through case studies. Different cases, each individual is a case for us. We look at their social status, their economic status, the political participation, the society they live in, their employability, their savings, all things can be taken into consideration, whether in the marriage and divorce case. It's not about alimony, other things, because our marriage problems, divorce happens because laws tend to support either party, either way. But we need to collect evidence things, because if marriage falls, it is not always the one or the other. It might happen both parties in wrong things. And certain times, many times, they may not have the strong evidence for that. Because in marriage, evidences are different to find. So you have to realize, find it out. So that can be possible by using those methods. And then I said sometimes lawyers look at field study. Now, I ask many lawyers to look at field study to see that how particular act or particular provisions of an act has been helpful. For instance, we look at law says that is a CSR is mandatory in corporate law. How many cases is there? Where this money has gone? Has the CSR money really brought a drastic transformation at the ground level in terms of afforestation? Whether really corporate governance has what is mandated is happening in smaller companies, middle-sized companies, SME firms, or not? So this we can only know when we go to the field. Now there are child protection mechanisms. We have laws for that. But whether such, many cases we have found destitution homes, child-led homes, how they have become center of criminal things. So that's only field studies. Many cases that homes for destitute children, women, tribal children, they have been used as a prostitution mechanism. So you find out that only possible when you really look into field study. Whether it is dowry death, whether it is domestic violence, whether it is what is called intimate partner violence and live-in cases. Now Supreme Court has said, okay, live-in cases, you find when you went on your own, after 5 years, you are saying a complainer for rape. When that relationship, that conjugal, that relationship was based on consensus. Now suddenly, because there are problems between you and you said it is a violation. So you need to look at, and a lot of data comes through that. And the more the data comes through and clearly analysis there, it actually always helps. Now the principles of law says the lawyers are nothing, but they are officers of the court. Now, if the officers of the court have the data with them, analysis with them, interpretation with them, then certainly it will help the judges to arrive at better conclusions. So it is therefore the need of the law students, the lawyers, to get into the research to establish this truth. Because the fundamental principle of or what is called lawyers ethics is that they are supposed to find the truth. And they must help the courts to arrive at truth. Now, that truth can be possible only through research, because research is a mechanism to arrive at truth, to source the truth. And that is why this interpretation analysis of data are important for us. Now, there I will give you certain cases, some studies where socio-legal researches have been done using different methods. Like if I am using a method like field work, so I need a questions. So I have to have a technique of questionnaire. If they are illiterate people, I have to question them and then write down the responses, because I cannot give a written questionnaire to them. I have to use an interview method. If there's two big people, I'm questioning retired judges, I'm questioning retired police officials, I'm questioning to the child right officials. So I need to have an interview, sometimes a focused interview. So these are methods. Sometimes we need a survey. Now, all if you want to do, so these are methods. And there are people who have done this, use socio-legal methods to legal theorists, jurists, experts who has done that to give a new perspective was in study of law. Many years ago, this William Samley's work on the theft, he talked about who is theft, how theft happens, what are the issues there. I mentioned that. Similarly, we look at Gusfield's work on that, or Friedman Laden's, who talked about the compensation theory. Is actually based on a capitalistic demand that they, instead of what is in touch, only unilateral damages, will find out a fixed term industrial disputes, so that it can serve the interest of the industrialist than the victims. Galantar is a work that you talk about in the one thirds in one third player and multiple players, and similarly Richard Kostiner's work on economics of. So there are many thinkers and who has used their legal and social interest and knowledge to give us a new and definitive perspective in study of law. Okay, in social legal methods. But most important part, both in law and social science, is what I call an objectivity. Because you said law has to be linked to the question of objectivity. So what are this idea of objectivity in that sense? Conclusions arrived at result of inquiry and investigation are independent of the test. Now, when I say objectivity, many times our decisions are based on subjective things. For example, if it is a black versus white, so people said, okay, black person's testimony is understanding his support. We thought, no, he is not good enough to do that. Similarly, testimony of women, testimony of children, color, nationality, occupation. Should have a poor man, he probably said lie. It's a carpenter versus a corporator. So we said no, corporate probably said more than good evidence than thing. So when we look at the conclusions arriving at, not the moral political preferences or observations, but predispositions, but independent of them. So that is why we try to always find out object. That it is not matters, but we have to find out if the evidence, if you want a fact, then how good it is. And it is not based on somebody's caste, class, color, religion, language, etc. We think that his opinion and his choice is important, is critical for us, irrespective of where he stands or who he is. If he says he has seen a witness, as a witness, as a witness, not necessarily whether thing. Yes, we can find out that whether that witness is dependable or not, different test. But he's not dependable because he is of dark in color, a short in height, or of woman, or of this particular political culture. It's not. So that would be an unbiasedness. So unbiased opinion is the best test when we talk about an objective. And then therefore you find a lot of cases which are actually, I talk about why research is important, because you look at all these cases I am sharing with you, and you look at the case studies, then you would know how legal research has actually helped us in understanding the vast terrain of socio-legal research. For instance, somebody said that Dunning versus Stevenson. We all read that case in terms of this. Similarly, we all read that case, and then that's the case of tort law. But you know, we rarely understand that the socio-legal dimension to that. Now, if you look at Dunning versus Stevenson case, it is not an individual versus another individual. It talks about it talks about a third party. No, it is not the client who was sitting for the drink and the server or the servant who served the drink. It is talks about because it was a sealed bottle, it made by a company, so it's the product liability, not the person who served it. And product liability happened only when we bring into corporations or companies into that. Till then, law of tort talks about the person who directly responsible or who suffered it is. So in essence, then the litigation has changed that we need to think about there could be an individual person who suffers negligence by a corporation, and there could be many such. So bring them into ambit. So it talks about a question of industrialization. Similarly, if you look at the case called Farwell versus Boston and Worcester Railroad Corporations, it talks about a case of again a case of negligence, but it's a case of contributory negligence. So it's again a principle of tort law brought into that, where it is said that not always for a negligent act of an employee, the employer to be wholesale responsible. He said there are certain cases where a risk is involved and the person is aware of the risk and he is supposed to entrusted with the knowledge which will protect him from the risk. And despite if he has suffered this, then there could be limited liability, not what is called no fault liability or absolute liability on that. So that happened, that decision, the judgment came in a way to protect the early days of industrial civilization, where the society believed industrialization will bring prosperity to society. Similarly, look at Reg versus Baldwin, now the cases talk about it. Or see Miranda versus Street of Marriage, now we talk about the child rights. Or Brown versus Board of Education, which talk about the discrimination in education. Right? Or Roe versus Wade, which I discussed sometimes, is about the child, the right of the right of the fetus versus the right of mother, abortion rights. So all these issues, if you look at, they are not merely legal issues, they are also social issues. Because Roe versus Wade talk about the Catholics' conception of conceptualization, conceiving things, and then it's God's gift, and then I have to find about religious dimension to that. Versus individual rights, collective rights versus individual rights. Brown versus Ford about again community rights versus one community versus another community, of racial things, discrimination. So whether it is race discrimination, as it happened in Brown versus Board Education, whether it is privacy issues between the individual and collective rights, religious rights, and personal freedom, whether it is Miranda case, which talk about the right of the children to things, and whether Rege of Baldwin's about administrative law. So we look at all these cases are not merely a legal remedial solution, but they involve deep social dimension that. And that needs to be understood. Then we need to do serious research into them. And therefore, social legal research, all this knowledge that produced are part of a social legal research, social legal dimension. So law doesn't exist in vacuum. There are significant sociological or political economic dimension to that. To understand that, analyze them, interpret them, get into details of them, and systematically analyze them requires a skill. And that skill is a research skill. And that is why the more you know about it, the more you are understanding them, then you do this. Last but not least, what actually the most important dimension of research, as I often say, is humility. That a researcher will never say, I know everything. The moment you know, I know everything, it's gone. So you have that humility knowledge. Because if you have knowledge, then you become human. You show humility.
You said, okay, I have tried to express it. I tried to understand it, but there could be fault, there could be problems. But this is my perspective, and it is open to criticism. It's open to interpretation. It's subject to analysis, subject to criticism, subject to addiction of new facts, and maybe subject to rejection. You don't know. A lot of theories you have rejected that. So therefore, it's an effort in that direction to acknowledge. And I have quoted Immanuel Kant who said that limitations of mind, that for every research we said that the limitations. There are limitations of form, limitations of time, limitations of abilities. No, there are a lot of limitations out there. But we transcending those limitations, we are in a position हम वहां खड़े होते हैं जहां पे हमको दिखाना पड़ता है कि we have अपने प्रोसेस किया, एक एफर्ट किया to present the facts before you. I have tried to analyze and interpret them, but these facts जो आपके पास है, आप खुद भी आपको एनालिसिस कर सकते हैं, देख सकते हैं. My opinion is not all and be all and end of it. एक मेरा ओपिनियन है इन फैक्ट्स को लेकर, और फैक्ट्स सबके सामने, interpretation अपनी है. Are you agree or disagree? It's up to you. So that is what actually, in a sense, we talk about in the research. Okay, so that's why I wanted to read. But the last and other things, if you look at the research, it's actually complex. तो हम लोग जितना रिसर्चर है, मैं मानता हूँ कि एक रिसर्चर के होने के नाते जैसे हमारे पास ऑब्जेक्टिविटी होना चाहिए, जैसे हमारे पास ह्यूमिलिटी होना चाहिए, जैसे हमारे पास बाकी रिसर्च होना चाहिए, ऐसे हमारे पास एक कंपैशन भी होना चाहिए as human being, because I think human research is human research. So our compassion doesn't necessarily mean that it will guide as a value to research, but you must be compassionate, you must be concerned for society. That is why you can say, whether you are in corporate job, I have no problem. Whether you are in industrial setup, I have no problem. Whether you are in social setup, I have no problem. But as long as you take care of yourself, take care of society, you have a conviction to bring good to society, a method to do well for society, and that sort of compassion, that sort of understanding is very, very relevant to that, for anything. So that is why to become human is also important. And instead of merely as a lawyer happened in the textual law as scientists themselves, despite engaging with facts, also have a human side to that, a compassionate side to that. So all of us should have done that. Not within the limit that our compassion should not override the facts, but our facts also not even imposing on people. In the sense, in the law, it's created by the people for the people. First, we should benefit in the sense. Therefore, you could find certain compassion for that. I will give an example and end it up. There was a case, many cases happening nowadays. The courts are actually looking at differently. The case was that a 15-year-old boy fall in love with, or a 15-year-old girl fell in love with a 16-year-old boy, and both are minors, so they eloped and get married, and then his parents filed a case. The girl's parents filed a case against the boy of elopement of underage child. So what had happened in that case? So then it's a case of rape, and the boy was caught, and it was there are some problems. The girl was came under the contact of the parents, and they enforced that the case would be there. So for 1 or 2 years, the case is went on. The boy was immediately caught, and in the prison, the case continued. So in between, the girl suffered, and she realized her mistake, and she wanted to change that. She wanted to be with that person, with then boyfriend or husband, whatever she said. I want to stay there. She had made up mind, because teenagers, there could be mood swings, mood changes thing on. So she, convinced, she thought of that she has made a wrong decision by sending the boy as becoming accomplice to the parents, and then sending the boy to the prison. So she wrote on many things, but nothing happened, because then now I've taken its own course. Finally, when it went to the High Court, these things, then Bombay High Court saw that authority. So the case said, okay, we understand now that although their child, it could amount to be under the POXO Act, victim, all the things, but it was a consensual. Even the children have right to make love, to live happily, make a happy family. So considering all this fact, we are observing you all culprit and sending them free. But that's only High Court could do. So how many people have access to High Court, to good High Court judges? Even though it is a compassionate, it is considerate, So that consideration, that compassion is also, and humility is an important part of research. So if these things are integrated in research, I'm sure that we would have the full aim using socio-legal research in our law school patterns, in our legal studies pattern, and deeply get engaged ourselves with society, not as merely studying law in the classroom, but at a participating law in society, becoming an active, vibrant participant in our social discourse, where law and society meets together, discuss, debate, dialogue, and then make better, more reformed, concerned, conscious, active human beings. So that is the end. That's what I wanted to share with you. And I think it's time. So I will stop here. If there are questions, I will take answer. So Namrata would know that again, if I come to the class at 1, so I always take that 1 hour class without giving time here and there. That is why many times my students don't like me. So that's so you should give some some time delays for that. But that's what biological clocks are. As a teacher, I will be there. So with this note, I'm thanking you. And now, if you questions, I'll answer. Thank you.
Yes, participants, I request you to kindly write your questions in the chat box. Okay, you can also unmute yourself to ask the questions.
कोई बात नहीं नम्रता
नो क्वेश्चंस ओके
अरे सब एडजस्ट होते हैं क्लास में बच्चे होते हैं इधर होते हैं कोई सवाल नहीं पूछते हैं बस एग्जाम में पूछते हैं कि सर इतना सवाल इतना डिफिकल्ट सवाल क्यों पूछे है ना
सर वन क्वेश्चन हेलो
yes you are audible
sir my question is that if the sample is very less while collecting the data if I choose different methods of sampling like snowball sample or multi-stage sample but still if I'm not getting the data in a proper manner so how to cope up this sort of the issues sir in case of research
no thank you Ms. Rudharani. It's a good question and it's a very common question for students who are not studied methodology in the beginning. It is because there is a procedure. The procedure is that usually if it's a bigger sample like 4,000 people, 5,000 people, 10,000 people, so the sample should be 10%. But if it is 10,000 people, it can be 5% also. But if you take 5% sample in 20 people, then it is not possible. So when we want to make a sample, because that is why when you say multi-stage sample, snowball sampling, snowball happens when you begin with a small one and gradually, there are different dimensions to increase the sample size. But the idea is that always ensure that your sample size is around 10% of the total population. Right, that will solve. Secondly, if you want the case studies, see, you are working on domestic violence and you have 20 cases. Even or like marginal farmers or women entrepreneurs, you take 20 women entrepreneurs in one field. That is sufficient for a case analysis, case study analysis. But it is not sufficient for a empirical analysis of 20 people only. But if 20 people fully work, you're writing 20 pages about each of them, that's fine. So sampling, if you want to take a sample, the ideal is that if it is a smaller sample below 1,000, you take 10% of it. More than 10%, the 1,000, you can reduce this sample size to 8%, 7% like this. But nothing less than 5%. Yeah.
A little bit clarity about that. Actually, my area of research is tribal pregnant women health issues.
Yeah.
So that population, if I approach to the tribal people, the pregnant women population only will be less. So in my research findings, when I start writing the research findings, it is very accurate in nature. Then how can I rely on that to give suggestions to the government or something like that,
See,
based on the very smaller
yeah.
category?
See, in that case, what happened? Why do you take a sample? For example, you take sample only when we are unable to take the total population.
Okay.
See, for example, हमारा एक village लेना है. If there are 10,000 population, I cannot take 10,000 people. You know, 3 months or 1 year period.
Yes,
So
sir.
I have to take a sample. But if you have to take a tribal village which consists of 300 or 200 households, and there are only 40 pregnant women, so in
Yes.
that case, I can take only 40 pregnant women. But if you want to increase that, you can take 3 villages, so you have 100 women only, 150 women only.
Okay.
Right. So that will become substantive one. But if you take only 40 women, you have no fault. But 40 women, from that to make a sample, to make an theory is very difficult, because nobody will believe in that.
Yes, sir. Yes.
Yeah.
Thank you, sir.
Well,
So we have questions in the chat box, if you can check. Yeah.
I have to check it, right? Let me see.
I can read out also if you want.
No, I think I can see the chat boxes there. Okay, this is charts. There are 26 charts, I think. Yeah. iPhone, read them, please.
The questions are at bottom, sir.
One second.
Should I
What is
read
that?
it for you?
1 second. What can be ideal sample? I have answered. And then
About that.
are traditional socio-legal research methods sufficient to study legal issues arising from AI and digital technology? Thank you. It's a very, again, nice question. I think yes, because what do you call a traditional socio-legal research method? Because when you say sufficient to study AI, a few months ago, no, in fact, yes, a few months ago, I was invited by a journal to give an interview about the impact of AI in legal research. I said, look at 3 AI facility tools we are having at Gemini, ChatGPT, AI information are fine. So whether those methods are helpful or teaching, I said, yes, if you think that some cases have to be there, you are immediately finding difficulty. So you ask ChatGPT, you get it. But what happens is that unless or until you verify them, you are into a dangerous territory. Recently, Supreme Court has come about that many lawyers are using ChatGPT and then saying their cases, quoting cases which has never happened in Supreme Court or any other court for that matter. And that is court had said, look, this is what is happening. So similarly, even if I am working at AI issues or digital technology, like cyber law, is a digital technology, like cyber fraud happening. Now, when cyber crimes are taking place, which method were using it? We are reckoning how many people are suffering. Now, I will give a statistics. If you look at 2020 data from the BPRND, that is Bureau of Police Research and Development, they said the data, earlier 100% cases. Out of 100% cases, say there are 30% cases of rape and murder, 20% cases of property theft, and 20% civil, issues like this. Now, what happening from last 5-10 years, the number of cyber crimes have increased, which are more than 50% of the total crimes. And then, if it is happening, I want to study where it is taking place, which are major cyber crime spots. So, what methods I will take? Again, if I am studying a cyber crime, then I will take traditional social legal method, research method, like whether I am doing statistics in the field survey, whether I am looking at as an interview method, or whether I am observing things. In all the method I can use that. And obviously now what happens is modern methods are also comes like statistical packages. Now we are using advanced statistical techniques like ANOVA test, etc. we are using advanced statistics to look into the average crimes and then finding out the linkages. So that way, our statistical techniques are also improving improving over the years. Okay. Similarly, I think the traditional methods are important. And if we find a problem where our traditional social legal research methods are unable to analyze a particular case, then only you can think. Because till now, I have never found any issue where our traditional, as you say, traditional social legal research methods have failed. And in fact, I must tell you that 50 years ago, our traditional method was, say, about positivism. 40 years ago, it was about interpretation. Now we have new methods like ethnomethodology, nectography. Ethnography was there 100 years ago, but still it is relevant. Then people are studying literature, study of reverb literature. Then there is a netnography because you are studying from the net. So ethnographical research based on the net study. So our techniques are also being improved. And that is why I think these methods are still relevant, and they're still it is possible to do research on AI and digital technology based on those work. Because there are many methods. For example, we see digital signature, is work on that, or digital evidence. Now we are looking at whether digital evidence has actually helped in combating crime. Then we can also using this traditional social legal research to do that. And it's happening, and people are working on them. A lot of people are working on this cyber law or digital technology, and in fact, impact of AI on education and using the same traditional methods. For instance, maybe 10 years down the line, we'll see at the classrooms, class 10 students, whether AI has helped them in crack CBSE examination or not. That method we can examine by simple traditional legal measures. So I don't think it's a hindrance, because methods are also developing over a period of time. Are the new technology developing? They are interrelated. And that is why I said it's a science. Okay, thank you. I hope it helps you understand.
Yes. I think we are done with the questions. Yes. Okay. If you allow me, sir, can we conclude?
Sure. Thank you.
Okay. Thank you, Professor Dr. Tapan Mohanty, for an exceptional session on socio-legal research. Your insights into data analysis and understanding of law from different perspectives have provided our participants with a practical roadmap for field-based legal research. On behalf of Acropolis Institute of Law, we thank you for bridging the gap between sociological theory and legal practice so effectively. Your expertise has truly enriched this faculty development program. We are deeply grateful for your time and for sharing your research expertise with us today. Thank you, sir.
Thank you very much. Can I leave now then?
Yes, sir. Thank you.
Thank you.
Okay.
Good.
Good day.